Hello, everyone, and welcome to today's webinar. We will be discussing a very time-sensitive topic called General Data Protection Regulation, or GDPR. I'd first like to introduce myself. I am Katie LaHoulier. I'm the host of today's webinar. I'm the Academy Training Coordinator for TUV USA. I'd also like to introduce our presenters. Our first presenter will be Uwe. He is the owner and managing director for Rukon Group. Uwe will discuss the GDPR overview. We also have Scott Wilson, who is the Chief Security and Privacy Officer for Ventive Technology, Inc. Scott will discuss the GDPR implementation experience in USA and globally. And lastly, we have Scott Grossman, who is our Sales Director for TUV USA. He will discuss what TUV USA can do for you. I'd like to introduce our first presenter, Uwe. Uwe is from Nuremberg, Germany. He has job experience in telecoms, emergency services, and emergency dispatch centers. Uwe has earned a master's degree in risk assessment and compliance management and business administration. His personal motto is, "The more standards, the more fun." Why am I talking about GDPR here? Uwe will discuss his experience in information security, data privacy, business continuity, and risk management for over 20 years. Uwe has been a data privacy officer since 2001. He has been doing audits and management systems since 2004, and his team and him have been consulting, training, and auditing organizations globally. Please visit his website and social media accounts to contact him further.
Purpose, you're not allowed without consent to process data for other purposes. The individuals, they have to write for data portability. So if, for instance, you register with the website and you say, okay, guys, I want to remove to another organization with this data, please give it back to me. I want to transfer my data. So that's one of the individual's rights, and the right to object any kind of processing of PII as long as there is no legal requirement to process the data. Okay, next one, please. So the PII controller has a number of principles to take into account, and the core principle always is accountability. Controller means an organization, usually a legal entity, collecting, processing, storing, exchanging PII for specific purposes, to fulfill a contract for marketing purposes, etc., etc. And what we can see is the core principle is accountability, to be accountable and to be held accountable for all this data processing activities. And we have 6 European data protection principles just around this accountability bubble here in the middle. So, for instance, lawfulness and fairness and a transparent processing of PII. So the individual should always be aware of what is the controller doing with my personal data. Only processed for a legitimate purpose. So can be a consent, for instance, for marketing purposes, or can be in the light of a contract. So if you are purchasing with an organization, for sure you need to process some PII, or maybe a legal purpose. So there are a number of legitimate purposes to process data. Data should be adequate, relevant, and always in line with the so-called data limitation principles. So, for instance, if you process data for a shipment to an individual, you don't need necessarily the date of birth or the place of birth or something additional. So
yeah, it's coming now.
That's one of the core principles, that you limit the data to a minimum. Should be accurate, should be up to date always, should be stored in a format that allows you to delete data if it's no longer needed for any retention purposes, and you should ensure appropriate security, integrity, and confidentiality of the data. So the PII controller may be a legal entity no matter where it is located. So it may be an EU legal entity, maybe US-based, maybe South America-based, maybe Australian-based. So it doesn't matter where on this globe you are, as soon as you process personal identifiable information of a EU citizen, you fall under GDPR. That's one of the core things that we should learn from this webinar. And the next slide, please. With respect to the PII processor, so the PII processor is an organization that is processing PII, usually subcontracted for a controller. A controller may be processor in one, so if you operate your systems on your own, you're a controller and processor in one entity, but a controller may use subcontracted processors as well. So, for instance, if you are a processor for organizations that are based in the EU and you're processing PII for them, you may fall under GDPR as well. In the upper blue box, you have, for later references as well, the legitimate purpose for collecting and processing PII of EU citizens, which is a clear consent, which is necessary to perform a contract, compliance with legal obligations, vital interest of the principal. Vital interest may be, for instance, for medical purposes, to perform a task in the public interest. So if you need to collect data, for instance, airlines or hotel chains who need to collect data for legal purposes, for social interest, that's legitimate, and also legitimate interest of the data controller. So if you are under any kind of legislation or regulation, you need to collect data, it is allowed. So next slide, please. So why do we talk here about certification and what a certification body can do for you? So the GDPR is talking about a voluntary approach towards certification for controllers and processors, which is absolutely highlighted in the regulation in Article 42 and 43. So it's one of the things the regulation provides, that a controller and a processor may use certification to demonstrate its ability to be accountable for all this data processing and storage and exchange. One thing, just to let you know, the law or the regulation is talking about accreditation as well. A scheme is not yet available, but the things we demonstrate to you in this webinar are based on international standards. So there is already accreditation available, and what we hear through the grapevine from the national data protection authorities, things under GDPR will absolutely go in the same direction. So what we tell you and what we show to you here is absolutely in line with what will come up in the future based on GDPR Article 42, 43. So next one, please. So we have a couple of standards, and just going back to my motto, the more standards, the more fun. I have a couple of standards here for you. So there is an ISO 29100 series. Just to let you know, there are a couple of good standards that give you guidance, for instance, when it comes to controls to secure PII, how to conduct a so-called data privacy impact assessment. It's kind of a risk assessment. But in the ISO 29100 series, there's not yet a certification standard. There is not yet a data privacy management system standard. So there is no chance at this point to get certified for anything in the ISO 29 world. So some of you may have ISO 27001 in place, an information security management system. And that may be a pretty good approach to address GDPR requirements in an information security management system as well. So you have risk management in place, you have controls in place, you may get certified, there's an international accreditation scheme. So sounds like a pretty good idea. A couple of slides later on, we'll show you a couple of things you should keep in mind when you use an information security management system to meet GDPR, because there are some constraints. Some of you may have heard about ISO 27018. 27018 is a standard and extended control framework for protecting personal identifiable information in public cloud services. And remember the picture, the principal, the controller, the processor. So ISO 27018 may be a good approach for PII processors to demonstrate good practice in protecting PII. And the fourth approach here is a British standard, so BS stands for British Standard. There's a national standard, it's called PIMS, Personal Information Management System, which is certifiable, which is a GDPR-conform data protection management system. So next slide, please. So the ISO 29100 world, I repeat myself, you can't get certified against ISO 29100. There's no management system available. But I would like just to point out one thing. Here are the so-called ISO data protection principles. And they are in line with EU principles. I did the homework and I mapped it back and forth, the 6 EU data privacy principles, I mapped them with the 11 here from the ISO. So they don't use exactly the same terminology, but they are absolutely in line. So the important message here is we can absolutely use everything that is provided by the ISO world, by international standards, to meet GDPR requirements. That is the important message here. So the next slide, please. When we use ISO 27001, an information security management system, I have here a brand new picture of my hometown, Nuremberg in Germany. There's one thing I would absolutely like to point out here. You can see the city wall, you can see a number of gates here in this picture. So what you should really keep pay a close attention to is identifying the boundaries of a management system and the boundaries of certification to make sure that all necessary GDPR requirements and all processes that process personal identifiable information are covered by the city wall. And if you have things that are outside the city wall, like here farming, agriculture, and stuff around the city wall, it's called a outsourced process. So we need to be aware of determining and controlling outsourced processes as well. So when you use an information security management system, it's absolutely fine. But please be aware you have all the processes within your city walls that are used to process PII of EU citizens to meet GDPR. So it's absolutely an appropriate way to use an information security management system, but think about the city walls and think about the gates. So the gate for me is kind of a picture for handing over accountability for processing PII, for instance. So the next one, please. So ISO 27018, as I mentioned before, is an extended control framework for protection of personal identifiable information in public cloud environments. So we bring together an ISMS plus the ISO data protection principles. One important message here is to get certified under the extended control of ISO 27018, you need an information security management system in place. So a control framework without a management system as a basis is not certifiable. So if you want to use ISO 27018, which a number of organizations do, and Scott will talk about this later on as well, you need an information security management system as a basis. So it's an extended control framework. Again, the ISO data protection principles are absolutely in line with what the EU data protection principles provide. So it's a good approach if you are a processor, use an ISMS, use ISO 27018, and you may demonstrate the accountability. Next slide, please. So, and touching on the British Standard 10,012, it's a brand new version of the National British Standard. So it was republished in January this year, and was and now it's absolutely in line, it's absolutely conform with GDPR requirements, and that's one of the important messages. So, and this is the only data protection management system standard globally that is available at this time. There are some rumors in the ISO world that a data protection management system standard will come up in the future, but at this point, this is the only standard we have to demonstrate a specific data protection management system. The good news for the users of BS 10,012 is you may use it for a sole data protection management system without an information security management system in place. So you can use it as a single data protection management system standard. But there are no specific security and data privacy controls. That's not the biggest issue, but it's just something to keep in mind. And Scott Grossman will talk about BS 10,012 later on, a couple of minutes, since this is an appropriate solution for all that wish to demonstrate GDPR conformity and GDPR compliance. So the next one, please. Please don't get afraid by this picture because I brought together a number of standards. It's more a help for you if you refer later on to the material of this webinar. There are a couple of standards mentioned in here that may help you to implement, to introduce a management system that is in line with GDPR requirements, that may demonstrate a GDPR conformance. So it's a mixture of BS 10,012 plus an information security management system plus additional controls. So I don't want to jump into details here, but for those of you who are keen to use ISO standards, 29134 is an excellent standard for demonstrating a so-called data privacy impact assessment. And the data processors here in this webinar, I guess it's a pretty important exercise for you because controllers will get back to you and ask you, okay, what do you do to protect PII I hand over to you for processing, for storing? And it's an important exercise to understand the technical constraints, the infrastructure, the architecture of your system. So it's a pretty good standard. Okay, now next one, please. So my conclusion here is, and I know it's a lot of standards I'm just running through, but the important message here is don't be afraid of GDPR as a regulation, because we have material that is already available to guide you, to help you to demonstrate your accountability to protect the personal identifiable information of EU citizens. So, and the important message as well is that a company not located in the EU physically may fall under GDPR. So it's a help for you to use ISO standards. It's a help for you to use the British Standard 10,012 to demonstrate your accountability. But please do not underestimate the effort for implementation. So you need some time to go through to identify, okay, where do we have personal identifiable information, to assess the risk, to identify what controls you need in place to protect it. So Scott Wilson can tell a little about the pain he currently has with implementing all of these controls, and looking forward to hear from Scott about your experience. And so that's it in a nutshell, what I wanted to introduce.
Great, thank you, Uwe. I just want to point out real quick that if you have any questions regarding the presentation during the presentation, please feel free to enter them into the chat, and we will come back to them during the question and answer section. Thank you. Scott, this is for you.
Great, thank you. Thank you, Uwe. That was a great introduction. I want to make sure everyone can actually see my screen.
Yeah, it's there.
Yes.
Okay, great. So as Uwe said, I'm actually going to talk to you about, the actual process of going through and implementing, really a compliance program in a global company. Just a little background on myself. I'm Chief Security and Privacy Officer for Vincent Technology. I've got over 20 years experience, mostly in the infrastructure operations, data center operations, and security and privacy side of the house, and really the last several years have been on the security and privacy side. I can tell you that for the last 2 years, I've spent several hundred, if not thousands of hours spent studying, reviewing, and talking about GDPR and really what it means, both from a business standpoint, from a risk standpoint, exposure, as well as how do we operationalize this. So I have a lot of slides with a lot of data on them, so I'm going to probably talk fast through some of them, but you really want to impart as much knowledge and data points for you to take away and have the ability to kind of look things up on your own, or certainly reach out to me with any questions that you might have. One thing as you begin your journey down, being compliant with this effort from a GDPR standpoint, this is going to be the overall direction that really other countries and to protecting personal data of citizens, whether it be in the EU, Africa, Asia, India, and even in the U.S. So, as Uwe said, if you take these frameworks from ISMS or from the privacy PIMS standpoint, those are really frameworks that you can set up and establish that allows a lot of flexibility to be able to adapt to the other requirements as they come in. But as we talk about GDPR, one of the things that you really need to be aware of and really monitor for is essentially monitoring what the data protection authorities in the various EU member states, really what they're communicating from an enforcement standpoint, and so, one of the key DPAs that I keep an eye on a daily basis is the ICO, and, from an ICO perspective, you can see that, they're going to take a very proactive and somewhat aggressive approach in enforcing compliance with the GDPR. They actually say it's a carrot and stick approach, but really it's a stick approach to really enforcement if you don't take it seriously from a compliance standpoint. Real high-level overview of what I'm going to go over through today, but I'm not going to go through each of these, so I'm going to jump on. So I'm going to, from a GDPR perspective, just a couple things to point out. Uwe touched upon some of it, but if you really look at it, it is a complete overhaul of the data protection directive, and it really is essentially bringing data protection based on current technologies and the use of technologies out there. So Internet of Things, social media, all that stuff is now being looked at from a data protection standpoint. And while the law does harmonize data protection across the EU member states, there is still quite a bit that you have to watch for on an individual member state basis, because they can customize parts of it, and they can also add additional requirements onto the laws. Some other things to point out, really it's a significant increase in scope, both from a material standpoint and a territorial scope increase. But from a material standpoint, the definition of what personal data is has been greatly increased. And, now we're talking about things like IP addresses, MAC addresses, things that are typically talked about in terms of online identifiers, business email addresses. And if you look at the specific language, they talk about identifiable and identified really aspects of data. So you got to be careful when you start the process of identifying all the data in your systems. Obviously, there's a huge increase in data subject rights. There's a significant focus on that. And then, cross-border data transfers, not a lot of changes there, but you really have to look at the vehicles you have in place for moving data outside of the EU or the EEA. And then, when you talk about enforcement, you got to look at the administrative sanctions and financial penalties that are available now to the data protection authorities. So it's significant, right? 2% to 4% of gross global turnovers. So that could be a significant amount of money. And in some instances, it could be hundreds of millions of dollars. On the other half of the coin is, the administrative sanctions that are available to the authorities. They can essentially issue injunctions and cease and desist orders, which oftentimes could be much worse than even the financial penalties. So you need to be very aware that, these are significant risks from a business standpoint if you're not compliant or if you're not trying to be compliant. So real quick about Ventive Technologies to kind of appease my marketing guys, but also I want to set the stage for why Ventive is going down the path of being compliant with the GDPR. So we are one of the largest independent risk, safety, and insurance technology provider really in the InsurTech market. So we have SaaS and we also develop software solutions to help essentially companies manage their risk, insurance, and safety components of their business. We have well over 500 global customers, several Fortune 50 customers, which you can see that these companies typically touch EU data subjects, and so that's why we fall under the regulation from a data processor standpoint. But we also have operations from a business standpoint in the U.S., in Europe, and Asia. So we also fall under the regulation from a controller standpoint. We have well over 1 billion records that we host in our data centers, probably which 70% of them are what would fall under the category of personal data or sensitive personal data. And then we typically see about 12 billion plus transactions a year through our hosting center. So, 2 years ago, when really first started hitting the market, we went through the exercise of, does the GDPR apply to us? And this kind of a decision tree that I put together that you can certainly use for your own purposes. But do you have a legal entity established in the EU? If you do, then more than likely the GDPR is going to apply to you. Do you have any type of establishment in the EU? Do you have a website that targets or markets services within the EU? Do you offer services in language other than English in the EU, or do you offer transactions and in pounds and euros? And so if you can answer yes to any of those types of things, then chances are it applies to you. One thing to keep in mind too is like we have a number of our customers who actually have chosen to host with us in our European data centers, and while they're not collecting EU data, subject data in the systems, the mere fact that they're processing that data within an establishment in the EU now puts that data under the scope of the GDPR, and they now need to be compliant with the GDPR as well. So when you go through these exercises, you really need to be very deliberate and methodical with how you go about it and how you determine do you fall under it from either a legal entity standpoint, from a processing standpoint, or from a controller standpoint. And I can tell you that when we went through this exercise, we actually documented the entire process, our entire decision-making process, and how we arrived at this decisions that we have come to, and that's actually one of the requirements under the regulation is to be able to essentially document all your decisions and your processing activities. So just real quick again, why we have legal entities in the EU. We sell goods and services to EU. We process the data of both EU data subjects, and one thing to keep in mind too is we also process data of folks who visit the EU, so that actually falls under it as well. If you look at the regulation, it actually doesn't call out citizens versus really data subjects. So there's a little bit of a legal issue there you got to look at to make sure you're doing the right things. ffensive is both a controller and a processor. We're a processor from the standpoint of we process a lot of data on behalf of our customers, the controllers, but we also fall under the controller category from an employee perspective as well as a marketing perspective. So we're looking at the full GDPR compliance from both standpoints of being a controller and a processor. And actually one thing too is, once again, you're very careful in how you define personal data and what you process. So there's a lot of legal loopholes and catches that you can get caught up in, so you just need to be very careful when you go through the process. And so this, call it out Office 365 here, because a lot of companies actually choose to host Office 365 in the EU, even though they're a non-EU company, and actually the processing of that in the EU puts that data under the regulation. So why should you care about the regulation if you're not an EU company? Say if you're a US company, why worry about it? Well, you know what? GDPR has an extraterritorial reach, meaning you don't have to be established in the EU to fall under the regulation. And from a US company standpoint, US regulators, FTC, and the Department of Commerce, they've already indicated that, they will assist in enforcement actions, and really it's both from a civil and a criminal standpoint in helping to enforce the GDPR regulation when it comes to U.S. companies. Look, about 3 weeks ago, the FTC actually issued consent decrees against 3 U.S.-based companies claiming to have EU-U.S. Privacy Shield certification when in fact they did not. And then they also, the U.S. is going to sign trade agreements, from a global commerce standpoint, and really, it's going to be important that they demonstrate a willingness to support, global data privacy and data protection laws and standards. Processors now also have statutory obligations under the GDPR, which is something new. So in the past, you didn't fall under the legal requirements of having to comply, but the controllers did, but they had to have contracts in place to ensure data processors were processing data in a secure and legal manner. Data subjects in the EU now have the ability to sue for both material and non-material damages. That is something new. It's going to really open up the market in the areas of really some of the class action lawsuits. There's been some reports out recently about really this is going to be a potential cash cow industry for lawyers in the EU for data subjects claiming to have privacy right violations. So that's another, your legal exposure, your risk exposure is going to be way up if you don't have a compliance program in place. And, really the DPAs will be actively enforcing the regulation. I think if you look at, some of the more aggressive DPAs in Europe, Germany, France, the UK, you can kind of see, really what they're doing in order to get ready for it. But if you look at even Germany over the last 12 months, they've reached out to approximately 500 small to mid-sized companies, actually mostly U.S. companies, and asked them to fill out questionnaires and surveys to essentially demonstrate compliance with the current data protection directive, but they'll certainly be doing that when GDPR is in place. I'm not going to go through this one, but if anyone's really interested in going out and reading the regulation, there's a link for you to access that. But it would be a good point to at least go through the highlighted sections because that really touches upon some of the direct responsibilities for both controllers and processors. So some of the organizational challenges that when we started looking at this it's a big effort. Uwe pointed out, don't underestimate the amount of work and putting the right mechanisms and processes in place to be compliant. But GDPR really encompasses and spans the entire business. It's a legal issue, it's a contract issue, it's an IT issue, it's a sales issue, it's a marketing issue. So you have to have support and buy-in from the entire business to put an effective privacy program in place that meets the requirements of the regulation. You really do. You need to have executive buy-in. The risk that businesses face from this regulation really puts us at, really the executive and board level of decision-making, right? If you look at the fines, once again, it's significant. And you're also going to need the resources and dollars to make this happen. This is not a one-man project. Like I said, it's going to be a cross-functional effort across the organization to be able to pull this off. And it requires a fundamental change to how businesses operate. You really have to look at your business processes and relationships. You need to review them. You need to really inventory and itemize them and really put all the workflows together, both from an internal perspective and an external perspective. You need to look at your data governance programs that you have in place. In the past, everyone talked about that the big data problem is how do I make use of all this data that I have in my system? But really, GDPR introduces a new one, and that it's really a challenge of, well, how do I make effective use of this data from a legal standing, right? And you may have to delete, anonymize, or pseudonymize data fairly quickly based on once the initial intended purpose of that data process is complete. You don't have a legal basis for holding that data indefinitely anymore. So you're going to have some pretty strong data governance initiatives together. Data inventory and data mapping. This is actually probably one of the biggest efforts that we're going through, is identifying all the systems that you have personal data in and mapping that out. You start talking about your HRS systems. You start talking about recruiting. You even start talking about OS and sys logs, right? So if you're capturing IP addresses, or application logs, which is capturing, login information. Office 365, travel and expense, any learning management systems. I mean, you've got to identify all these endpoints that have data in them, and you have to have a plan for essentially protecting that data, putting retention policies and processes in place, and then also being able to demonstrate that you're following those processes and procedures. So, and last but not least, GDPR compliance, it's not a one and done project, right? It's an ongoing effort. As you change vendors, as you bring more data in, you've got to constantly be updating your documentation and systems to account for that. And, the law is still evolving, right? So we're still getting guidance from the different, not only the Article 29 Working Party, but the different data protection authorities on how to implement GDPR processes and procedures and how to be compliant. And once again, each EU member state has the ability to essentially customize parts of the law to meet, the individual state requirements. So it really is, it's a big effort. And you'd be surprised as you start going through it and the spider web of data flows that come out of it. When we talk about ffensive, when we start mapping out where do we have employee data, we identified essentially 28 different systems that employee data ends up in, right? That's our HRS systems, that's our payroll systems, that's our travel and expense systems, that's our LMS systems, that's our internal ticketing system, that's Office 365, the managers' email boxes. So you've got to, like I said, you've got to go through and do a very due diligence and effort in identifying all these different sources. Because if you do run afoul of the DPAs, there's going to be a cost to pay, right? When you start talking about privacy programs, you've got to have the right programs and processes in place to be able to respond to like data subject access requests and things like that. So, once again, high level, some of the things we've done is we have inventoried all the customers and vendors that we do business with. We're reviewing all the contracts that we have in place with both customers and vendors to make sure they're GDPR compliant. You know, GDPR requires certain language be in the contract, so we're going through all of that. And, you know, part of the challenge there is we're having to actually educate a lot of our vendors and our customers that this is required, you have to do it. Because believe it or not, listening or out, there's still a lot of companies and vendors out there that don't think they have to comply when in fact they do. You know, update privacy program, right? You need to have your privacy notices. You need to have a privacy policy. You need to have a data subject access request process in place. And I'm going to say, you know, one of the few things you do is make sure you do have a DSTAR process in place, is because that's where you'll probably see some of the initial enforcement actions outside of breaches where, you know, you don't respond to a data subject within the required time of 30 days. Because once you don't respond, that data subject's privacy rights have been violated and they can file a complaint. So that you can certainly be sure that the DPA's supervisory authorities will be following up on those pretty quickly. You need to look at whether or not you need to have a data protection officer in place. We do have one in place because of the large volume of data we process, but we also process sensitive data. So when you look at those, that's a requirement under the regulation if you process and monitor and track a large, you know, data subjects in a large volume. You need to make sure you have the right legal basis for processing the data, right? Employees, you're going to have a legal basis for processing employees. And GDPR has pointed out that with employees, consent is no longer a proper legal basis. You're going to have to rely on another basis for that processing. You need to have the right legal mechanisms in place for cross-border data transfers. You know, this is not only for controller or processor data transfers, but really, you know, intra-group type transfers. You need to have either, you know, like standard contractual clauses or binding corporate rules, or you need to be transferring data to a country that has a right legal standing in the EU. You need to go through and essentially categorize all the data and map out all the data you have. And as you've pointed out, DPIAs, data protection impact assessments, are going to be very important documents to have. And then record keeping. Yeah, record keeping is going to be very important, and if you look at it, it's like 52 out of the 99 articles require some form of record keeping. So, and one of the rights that the DPAs have under the regulation is that they can go to you and essentially ask for that documentation. So you need to be able to provide it to them within a timely manner, fashion, and it should be in a form that is easily understandable. And one of the requirements will also be is that you respond in the language of the DPA requesting that documentation. I'm not going to go through all these, but once again, you can see that, you know, documentation, record keeping is a cornerstone of demonstrating compliance and meeting the accountability principles. Article 30 really spells out a lot of it, but, you know, all the other articles, a lot of them also have specific data record keeping requirements. So once again, it's not enough to be compliant. You actually have to demonstrate compliance. And, you know, the record keeping is obviously an important aspect of that. You know, having a privacy framework in place that's flexible enough also to meet the GDPR requirements and also to meet any ongoing changes with GDPR, but also any other regulatory requirements that may be coming out is going to be important. And as Uwe pointed out, you know, the GDPR does call out specifically things like certifications, seals, and codes of conduct as being a means and a mechanism for being able to demonstrate compliance. You know, what we've done here at ffensive is we do have the ISO 27001 in place. We also have a SOC, but, you know, we really fall upon the ISO, you know, being an international standard, and, you know due to the scope of all the controls we have in place, it maps very nicely to a lot of the requirements from a GDPR standpoint, but we're also looking at doing the ISO 27018 because that specifically deals with privacy in the cloud. So, we want to have essentially in place a privacy program and a framework that we essentially, if we ever do get audited by a data protection authority, that we can easily provide this documentation to them, and they say, yeah, they've done the right things, and heaven forbid that we run afoul and we end up violating the regulation in some form. Having these documents and certifications in place is a mitigating factor. If we were to get fined, and the DBAs will take that into account if you have these types of frameworks in place and certifications to demonstrate how you've done things from a certification standpoint. I can certainly tell you that our customers who are controllers in our relationship have been and are starting to come to us quite frequently for this documentation so that we can demonstrate we're compliant from a security standpoint, from a privacy standpoint, because one of the requirements under the GDPR is that controllers only sign contracts with processors that can meet the requirements of the regulation. So as we get closer to next year and then closer to 25 May 2018, if you're a processor, I can certainly assure you that your customers are going to be coming to you more and more for this type of information. And then, if you're, a controller, these are things you should be looking at having in place or putting into place as a means of demonstrating compliance to the data protection authorities. And then, as kind of my last slide here, I just wanted to kind of touch upon, once again, some of the key changes in the regulation. Once again, data processors for the first time now have statutory obligations under the regulation. So there are specific requirements outlined in the regulation that data processors now need to follow. Record keeping, once again, very important. If you don't have the records and you can't demonstrate compliance, then in the eyes of the data protection authorities, breach notifications, this is new. Now there's a 72-hour requirement to notify data protection authorities of a breach where there's a high risk to a data subject. Actually, the specific language says without undue delay or no later than 72 hours. But they have not defined what without undue delay really means. Right to erasure, right to be forgotten. This is somewhat going to be new and challenging to companies, and how do we respond to this? And what does it really mean when we have to go in and erase, data? Because the funny thing about it is the GDPR will actually require you to keep a record of that communication with a data subject requesting you to delete their data. So there's a lot of things you got to balance out about what the language of the law says, as well as the language around the records you're set to keep. Once again, accountability. TUV pointed it out, but one of the core principles of it is establishing accountability from a data controller or data processor standpoint, that you're doing the right things, you're being transparent, you're only processing data on a legal basis. Data retention, to me, this is actually one of the biggest game changers in the regulation, because companies you cannot keep data in perpetuity anymore. At least you cannot keep identified personal data in perpetuity anymore. So you need to make decisions about what you're going to do with your data, right? And it's not just data May 25, 2018 forward, it's data before that as well. So you need to go through, and if you have large, data stores of personal data, you really do. You need to start making decisions around what you're going to do with it. Are you deleting it? Are you anonymizing it? Are you pseudonymizing the data? Or are you rolling the dice and hoping you don't get caught, Privacy by design, privacy by default, those are some challenges for businesses. If you look at the language around GDPR, they call out specific things like, encryption, pseudonymization, anonymization. These are all things you need to look at. One of the Article 32 specifically calls out things like the use of state-of-the-art. Well, what is state-of-the-art? So it's, like I said, you're going to have to be, when you go through the exercise, be very methodical in your decision-making process and why you made the decisions that you made, both from an overall data privacy standpoint, but certainly from the different components of the regulation. And then, once again, you're going to have to look at, do you need a data protection officer? All right, that's my last slide. Once again, if anyone has any follow-up questions, we'll be taking some at the end. But I'm also available via email and phone calls later too, if that would help anyone out.
Thank you, Scott. That was great. I'm just going to pass it over to Scott Grossman now, and we'll be taking questions.
Okay. Thank you, Katie. I appreciate that. Okay, everybody, I want to thank again for Uwe and Scott for some very informative presentations there. One of the things that I will just give you a quick thumbs up on is what we can do to help you and your organizations get through the processes. So as everybody discussed, GDPR comes into play in the middle of next year in 2018. But what can we do for you? As a global international certification body, we have a physical presence in over 70 countries with over $1 billion in annual certification sales and such. We employ over 13,000 direct employees plus many, many contract as necessary for doing your auditing and any assistance that we can help you in that. We currently have over 63,000 certified systems, over 40,000 clients right now in the certification world. So when you look at the next slide, Katie will show you, and you have to bear with me, Katie's doing that for me, is some of the certifications that we actually do. We are accredited by DAX, which is the German accreditation body, as well as ANAB, which is American for both ISO 9014, 18, AS 9100, and so on and so forth. But also the TS, transportation, the ISMS 27001, 50001, securities for safety, all the information technology standards, as well as we're in the process of obtaining our accreditation for BS 10012 and any of the other accreditations that are going to be necessary to help you get your certification and meet the requirements of GDPR. So that's one of the things that we can do for you, and we can assist in communicating with the people such as Scott and Uwe to make sure that you get through the process. I don't want to take up any more time than necessary, but Katie will also put up on your screens contact information for Uwe, Scott, and myself at TUV. If there's anything that we can do, feel free to contact us at any time. I promise that you will get the best support and knowledge that is out there in the industry. I'm sure that there are many questions because this thing went a little longer than normal, but that's okay. So I'm going to pass it off to Katie. Katie, you can go ahead and handle it and start pushing the questions out to everybody else. That would be great, and I want to thank everybody for joining us today. Katie?
Okay, great. Thank you, Scott. So I do have a question coming in, and this is it. Is there a grace period to become compliant after May 2018?
So this is Scott. I can take that. So the simple answer to that is no. So technically, the regulation GDPR was passed in 2016. So essentially, the grace period was the period between 2016 and 25 May 2018 for companies to come into a compliance status.
Okay, great. I have another one here. It says, what exactly is a joint controller, and where does the liability lie in this relationship?
So I can take that one too. So essentially, it's, joint controllers, there's a couple different examples of that, but essentially a joint controller relationship is where two parties are essentially making the decisions around the processing of data. So, you can see it a lot within within the same company where you have different business units essentially making decisions around processing of the same types of data together, and it actually gets somewhat complicated from a legal standpoint where you define the roles of both controllers and the liabilities around both controllers, but it is something that some of probably more of the larger corporations need to look at from a compliance standpoint.
Okay, great.
So it's here's Uwe, just to add one point. So it's a typical thing when you have, as Scott pointed out as well, so different lines of business, and when they are represented by different legal entities, but you have a construct of an overall enterprise. So that's kind of a joint controller.
Okay, great, thank you. Next one is, do we have to update our contracts with vendors?
This is Uwe. So at least you should take a close look into your contract to make sure that your, let's say, subcontracted processing is in line with your accountability towards GDPR. So it's not necessarily the case you need to redraw existing contracts, but what you should have in place to reflect to the state-of-the-art approach is to have a cycle in place to demonstrate you are frequently going through your contracts, maybe over a 3-year period of time, for instance, but to make sure you touch on your contracts and you review them in the light of GDPR, and if there's the need to add some more GDPR, let's say, GDPR required contractor information.
Okay, so since we're over time, I'm going to do one more question. And after this, please feel free to email us. You can, or go to our website at www.tuvusa.com, and we can answer questions there. So the last questions I have is, can cyber insurance cover regulatory compliance fines?
So, yeah, this is Scott. So, yes, with caveats, so the caveats being that if you're doing business in an EU member state that precludes, you using insurance to cover, non-compliance actions, then the answer is no in that specific state. So, this is where you're going to have to be very methodical in identifying, what countries you do business in, and then looking at the different risk in each country. And so, yeah, there you
go. Okay, great. Well, thank you very much. I want to give a quick thanks to Uwe, Scott Wilson, and Scott Grossman, and also to everyone joining us today.
So thanks to all.
Thank you.
Thank you.
Thank you, everybody. Have a great day.
Have a great day. Thank you.